Secretary of State and Servier Laboratories concerns the circumstances in which, under EU law, a finding in a judicial decision by an EU court is binding in later judicial proceedings. It is concerned with the scope of a principle of EU law known as absolute res judicata. The appellants, to whom I will refer collectively as Servier, developed and manufactured a drug, perindopril, which is used to treat cardiovascular diseases and which falls within a class of medicines known as ACE inhibitors. The respondents, who are the claimants in domestic proceedings against Servier, are the national health authorities of England, Wales, Scotland, and Northern Ireland. Between May 2011 and September 2012, the claimants issued proceedings in England and Wales which alleged that Servier had, first, breached Article 101 of the Treaty on the Functioning of the European Union, TFEU, and/or Chapter 1 of the Competition Act 1998, by entering into anti-competitive agreements with potential generic manufacturers and/or suppliers, and secondly, had abused its dominant position in the market contrary to Article 102 TFEU and/or Chapter 2 of the 1998 Act. The claimants contend that this allegedly unlawful conduct has delayed the entry of cheaper generic versions of perindopril onto the UK market, which has, in turn, caused the claimants to suffer substantial financial loss. Servier's conduct relating to perindopril was investigated by the European Commission, which in 2014 issued a decision which found that Servier had infringed Articles 101 and 102 TFEU. Servier appealed to the General Court, seeking the annulment of the Commission's decision. The General Court judgment upheld all but one of the Commission's findings of infringement of Article 101 TFEU, but found that Servier had not infringed Article 102. This was because the relevant product market was not limited to perindopril, but extended to ACE inhibitors generally, and Servier did not have a dominant position in that wider market. Both the Commission and Servier have appealed to the Court of Justice of the European Union. As there are significant overlaps, the domestic proceedings cannot proceed to a final trial until the EU proceedings have been resolved. However, in October 2016, Servier was granted permission to plead in the national proceedings that the claimants failed to take reasonable steps to encourage switching from the prescription of perindopril to cheaper generic ACE inhibitors. Servier asserts that, even if liability and causation are established, the claimants' damages should be reduced or extinguished because the claimants failed to mitigate their loss, or contributory negligence, and because the losses claimed are too remote. At a trial of preliminary issues relating to this argument, Servier argued that certain findings in the General Court judgment, in particular concerning the extent to which perindopril can be substituted for other ACE inhibitors, are binding on the domestic courts. However, both the High Court and the Court of Appeal held that none of the findings relied on by Servier are binding for these purposes. Servier appealed to the Supreme Court. It claimed that the point of law is uncertain, not act clear, and that the Supreme Court should therefore refer the question to the Court of Justice under Article 267. The Supreme Court unanimously dismisses Servier's appeal. It holds that the General Court findings on which Servier relies are not binding in the domestic proceedings and declines to make a reference to the Court of Justice. The short and complete answer to Servier's appeal is that the EU principle of absolute res judicata only applies to judicial decisions which have become definitive, either after all rights of appeal have been exhausted or after the time limits for exercising those appeal rights have expired. The General Court's findings are not yet definitive and may never become definitive because they may be reversed or rendered redundant in the appeal proceedings before the Court of Justice. The findings are therefore not binding in the domestic proceedings under the EU principle of absolute res judicata, and a reference to the Court of Justice is not necessary in order to decide the issues in this case. The Court, nevertheless, sets out its views on the underlying issues of law in the hope that they might assist at later stages of the domestic proceedings. Where the EU courts have annulled a Commission decision on substantive as opposed to procedural grounds, the substance of that judgment becomes binding generally, not just on the parties. The purpose of this principle is to prevent the annulling judgment from being called into question in subsequent proceedings. This purpose is the key to the principle's scope and applicability. The outcome set out in the operative part of the judgment and the essential reasons for the judgment, which explain why the Commission decision has been annulled, are binding generally because those are the aspects which must be respected in order to prevent the annulling judgment from being called into question in later proceedings. In this case, the General Court judgment annulled the Commission's finding that Servier had infringed Article 102 on the basis that the Commission was wrong to conclude that the relevant product market was limited to perindopril as opposed to all ACE inhibitors. The General Court made a number of findings of fact in this regard, including those Servier relies on. Accordingly, if the General Court judgment becomes definitive, and it can be shown that the relevant findings were an essential basis of that judgment, it would not be possible to challenge those findings in later proceedings which sought to contradict the General Court's conclusions on the relevant product market within Article 102. However, it is not necessary to treat the General Court's findings as binding in any other legal context. If the Court of Justice upholds the General Court's decision that Servier did not infringe Article 102, the claimants will no longer pursue their Article 102 claim. In any case, Servier relies on the findings to support its defence based on mitigation of loss flowing from alleged anti-competitive agreements contrary to Article 101, not to define the relevant product market for the purposes of Article 102. The General Court's findings cannot be detached from the authority of the annulling judgment and deployed in this wholly different context. Servier's submission that the General Court's findings are binding in any EU law proceedings which raise the same factual issues is incorrect. It is not supported by EU or domestic case law, and it is also inconsistent with the purpose of the EU principle of absolute res judicata. Servier's proposed approach also raises practical difficulties because it has no workable defined limits. More generally, if it is confined to the context of the consequences of an annulling judgment, the principle of absolute res judicata promotes legal certainty, the effective judicial control of EU institutions, and the maintenance of the EU legal order. However, once freed from this restriction, it could operate in a way that is arbitrary and unjust, binding persons not party to the original dispute in a wholly different legal context, in a way which would be inconsistent with the principles of a fair trial. The claimant's claims in the domestic proceedings do not call into question or undermine the General Court judgment or its consequences in any way, nor do they contradict the General Court's decision as to what needs to be done to comply with EU law. It is therefore clear that the factual findings Servier relies on are not binding in the proceedings before the courts of England and Wales, because the EU principle of absolute res judicata does not apply. For these reasons, Servier's appeal is dismissed.